on probation right now. He just got sentenced January 21st to 25 for financial transaction device stealing, retaining. The reason I'm asking for a tether with curfew is I believe he is a flight risk. The register of actions, which I did forward to Mr. Reagan, shows that Mr. David failed to appear for his sentencing in that case on December 10th of 24. Even though the register of action shows that he had a tether, Your Honor, he was arraigned on that bench warrant 20 days after he was supposed to be sentenced. He had to be re-referred for a pre-sentence investigation report, and then he got sentenced January 21st of this year. So he just got a sentence on that because he did not appear for his sentencing at the end of last year. We believe that indicates a flight risk, Your Honor. And so we're asking for tether and a curfew, but I'm not objecting to personal.
I can't have a tether.
Hold on. What I want to know, Counsel Douglas, is he capious at sentencing, but then he was sentenced, correct?
He was sentenced January 21st.
Okay. And does he have any other pending cases?
Yes, Your Honor.
Only one?
He just got arraigned on Friday for a different retail fraud, although the date of offense on that one was October of 24. He got arraigned on that Friday.
Okay. All right, go ahead, Counsel Reagan.
And there's a lot of times we don't know what happens, why people miss court for whatever reason, whether in the hospital, whether in some other facility. Sometimes that happens. He got sentenced. He did come. He's on probation now. This is a retail fraud third and the RNO judge. So I'm asking for personal bond in this matter. He's on probation, so he's going to be monitored, Judge. He just got sentenced to probation, so he does have some monitorization. So I don't think a tether is necessary in this particular case.
Counsel Douglas, do you know whether or not he has GPS tether at all?
You know what, Your Honor? I do not know. I just know that he has probation. I don't know that oh, you mean on the bond? His bond from Friday does not have a tether.
Okay. All right. So he picks up another case. He's on probation. He commits another offense, and then he commits this offense. He got personal bond on the
that's not right.
pending
That's
case.
not right, Judge. That's not right. That's
Counsel
not right.
Douglas,
No,
I
Your
want to
Honor.
make sure.
Okay. So he didn't
Let me make sure.
Okay.
He was sentenced to probation on one case. I got that. Does he
Yes,
have
sir.
another case?
Yes.
Yes, Your Honor.
Okay, so he has another case. Just so he got sentenced on one. He's got a retail fraud on another.
From
and then
October
this retail
24. From October 24.
I got that.
Because you just
I
said he
got
picked
that.
up a case, then picked up another case. So that wasn't how it
Well,
went.
he picked up a case. He picked up a case while he had a pending case, which he got sentenced to.
I don't.
That's
I don't
correct.
know.
I do. Yes, that's
No.
correct.
Yeah.
He was arraigned on the case he's on probation for. He was arraigned July 25th, 24. So the new case was picked up while he was on a personal bond with a tether.
Okay.
October. Correct. October.
All right. So he's got two cases plus this case.
Correct.
All right. All right. But in this particular matter, there was some, he was giving some commands by police officers. Allegedly, he was trying to run, disregarding police officers' commands. They took him to the ground. I'm gonna give Mr. David a $25,000 personal bond. Mr. David, I think you should go to tether, but I'm gonna give you one more chance, sir. $25,000 personal bond. I'm not gonna place you on a tether. Understand, sir, if there's any violations on this case, not only will you probably look at a monetary bond, but you're also gonna be looking at some sort of other additional bond conditions. Do you understand that, sir?
Yes, Your Honor.
All right, that concludes your arraignment. You can step aside. Gentleman who's seated down, what's your name, sir?
Larry Jovian Johnson.
James Jefferson.
Larry Jovian Johnson the second.
Yes, ma'am.
Thank you, sir. This magistrate at charge today, I hear a criminal matter. Case number is 250-5580601, sir. You do have an attorney. Go ahead, Counsel Reagan.
On behalf of Mr. Johnson, waive the reading, stand mute. He's been advised of his rights, Judge.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 19th. Hold on. Oh. Court dates are February 24th, 2025. It is a probable cause conference followed by preliminary examination. March 3rd, 2025. Both matters are in front of Judge Shakay. Okay, Mr. Johnson, let me give you some bond conditions.
Yep.
You're not to have contact with the Dominique Woods. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. Counsel Douglas, go with your bond recommendation, please.
Yes, Your Honor. On Mr. Johnson, the people asking for 50,000 cash or surety with tether house arrest that allows for work only. With Mr. Johnson, he does have multiple priors. Here we have the allegation that he shot the firearm at the complaining witness. There is a file note indicating that the 11-year-old child and the 9-year-old child of the complaining witness were witnesses to this, Your Honor. So this is something that's allegedly happening in the presence of children, Your Honor. As far as priors go, he does have a 2018 domestic violence, 2019 felony interfering with electronic communications, and then in 2014, I know that the HAB notice says that he had the felonious assault, but he actually had 2 convictions for felonious assault in that case, not one count of felonious assault, but 2 convictions for felonious assault. So he does have a history of assaultive behavior. Here, he allegedly was firing a firearm, and when police executed a search warrant, 10 days passed in between the alleged incident and the execution of the search warrant. Officers did not recover a firearm, but they did recover numerous ammo, which could indicate that there really was a firearm, Your Honor. And police did recover a casing, which corroborates the idea that he did in fact shoot at this complaining witness. So we have a gun that's at large, Your Honor. We have this allegedly happening in front of children, and we have an extensive history of assaultive behavior. We're asking for 50,000 cash or surety, tether house arrest that allows for work only.
Judge, they didn't even sign the
Sorry,
case.
say that again, Counsel Douglas.
I said 50,000 cash or surety, but tether house arrest that allows for work only.
Thank you. Go ahead, Counsel Reagan.
Judge, they didn't even sign the warrant until February 11th. They say this happened allegedly back in December on the 20th. But nobody cared enough to sign a warrant until February 11th. I mean, we talk about how dangerous these situations are, but I mean, my client hasn't seen this person. They don't live together, Judge. She's not going to go hasn't went near her. I don't think there was any other allegations since then. I know he has a 2014 case and then a 2019 financial transaction case, but Judge, he has 4 kids. He lives in the city. He's not going to have contact with her if you tell him not to. So I'm just asking for a personal bond, whatever conditions the court wishes to impose, Judge.
Thank you. Court heard the allegations from both sides, uses clear convincing evidence standard when it's entertaining monetary bond. Court sees the felonious assault conviction from 2014, domestic violence conviction from 2018. Bless you. Interfering with a electronic communications device. That's from 2019 out of the 22nd Circuit Court. Let's see what else. Yes, those matters. Court read the allegations in the investigator's report. Even though there is just about a couple of months, almost 2 months before the date of offense and today's arraignment. Okay. Allegedly, he had firearm, supposedly numerous ammunitions and a pistol magazine was recovered from his bedroom dresser drawer. That matter. Based on everything, he's got a history of violence just a few years ago. Let's see if anything else. Court's going to adopt the recommendation, $50,000 cash surety. Court does find that Mr. Johnson, he is a danger. The court is also going to place a GPS tether on him. And I'm sorry, Council Reagan, can you tell me, does he work?
Yes, he does work. He
Okay.
does work.
Okay, so GPS tether, work only. And with that being said, he is going to get a bond redetermination. It's unaffordable. Is that correct, Council Reagan?
Correct. That's correct.
Okay. That'll be February 19th, 2025, 9 o'clock in front of Judge McConicle, who will look at the bond amount and bond conditions. Thank you.
I'm sorry, Your
That
Honor, what was the
concludes your
dollar
arraignment,
amount?
Mr. Johnson. $50,000 cash surety,
Thank you, Your Honor.
GPS tether, work only. Sir, what's your name?
David Jermaine Jimerson.
Mr. Jimerson. Sir, this magistrate at Chartea here at a criminal matter, case number 230-4415601. Sir, you have an attorney. Go ahead, counsel.
Bring it on behalf of the ready for reading, stand mute. He's been advised of his rights. Judge.
Thank you. I'm gonna enter plea of not guilty. Court date is February 25th, 2025. Free trial in front of Judge Austin Garrett. Mr. Jimerson, some bond conditions, sir. One, you're not to have any contact with a Tamara Wade. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Let's see. It looks like Tamara Wade Jr. So both Tamara Wade and Tamara Wade Jr. You're not to possess any firearms or any other dangerous weapons. And you're not to go back to the Plainview residence. Do you understand those bond conditions, sir?
Yes.
Council Douglas, go ahead with your recommendation, please. November 4th, 2024, a warrant was issued for Mr. Jimerson. Bond was set at. We cannot appear via Zoom.
Jennifer Douglas for the people, P72748. Your Honor, with Mr. Jimerson, the people are going to ask for a tether in lieu of the money bond. If the court is not inclined to order a tether, then we would ask for the money bond to stay in place. This is Mr. Jimerson's third failure to appear in this case. He first failed to appear March 15th, 23. Arraigned on the bench warrant March 20th of 23 and his bond reinstated. Then he failed to appear at a pretrial 8th of 2023. He was arraigned on that bench warrant March 24th of 24. So, Your Honor, 10 months later, almost 11 months later, he was missing on the case. He was given another personal bond, Your Honor, and then he was given the opportunity to have the case dismissed if he completed certain actions, and then he failed to appear on the date where the court was going to check to see whether or not he had completed those actions. So, seeing how this is the third failure to appear in an assaultive case, we are asking for a tether in lieu of the money bond, and if the court's not open to that, we would ask for the money bond to stay in place.
Council Council Reagan, go ahead, please.
So, you know, he was capious, Judge. Now, he had an unusual situation. He had 2 counts of domestic violence on a case. One of the counts was dismissed and the other was continued to a final pretrial. So his mind, he thought that when they dismissed the domestic violence, the whole case was dismissed. And that's normally what happens when you have one case, but he had 2 counts on a case. It was 2 complaints, I believe, and one was dismissed. He got confused, Judge. That's why he capious. You know, he was homeless at the time as well. He was going through a lot, Judge. Now has a very, very good job that he is trying not to lose. He didn't have a phone at the time. He now has a number. We have good contact information for him now. He's working now. And I don't want to see him lose his job, Judge. He explained to us the reason why he came this before and was straightforward about it. So I'm asking the court, he has to appear in person. And we told him this. If the court is inclined to give him a personal bond, when you go to work, you come down to the courthouse. You can't appear by Zoom. You have to come in person. So we're asking that he be released on a personal bond. It's a misdemeanor, Judge, domestic violence. He hasn't had contact with the person. To my knowledge, hasn't been any violations of that. We just had some CAPIS issues. We did have CAPIS. Ms. Douglas stated it was CAPIS issues. So I'm trying to explain to the court why he had those. And I'm hoping the court will see that, give him one opportunity so he doesn't lose his job to come back to court, because he says he will. He now is stable. He's stable right now, Judge.
Your Honor, the dismissal of the one count isn't why he missed this last date. He was arraigned on a bench warrant after that, and then he appeared for court April 11th of 24. It was May 2nd of 24, where he was given the offer that if he did certain things, it would be dismissed, and then it's November where he doesn't appear. So he showed up for court 2 times after he was arraigned for not showing up after the dismissal of the one count. So that's not why he missed this last time.
Well, that's the original reason, Judge, why he thought the case was dismissed. Now, he was homeless. Like I said, he was homeless. He had some other issues. He is now stable now. But during that time, Judge, he was going through some things. But initially, he thought the whole case was dismissed.
Okay, Council Reagan,
Yes, Your Honor.
when did he stop being homeless?
When did you now get your home? When did you get your home, Mr. Jameson?
Approximately like 2 weeks ago, 3 weeks ago.
So up until 2 or 3 weeks ago, sir, you're saying that you were homeless?
Yes, I was from house to house, trying to find like homeless meal shelters. It's been kind of hard to get into a couple of those, but been basically living from like house to house, friend to friend. Sometimes I sleep at churches if I can. But I'm stable now. I have a good job.
And Judge, he has a good job now, too.
I've been working with the job for about 4 days
Thank
now.
you, Mr. Jefferson. I appreciate it. Thank you for all that information. However, counsel, okay, he could have had, and he could have come in, if he wasn't working and he didn't have a place to stay, he could have come into the courthouse, indicated that he missed his appointment, his court date with Judge Garrett. But that didn't happen for whatever reason. He has 2 other priors of KPS history. So, but he is working based on his representation to you and to the court.
Just got hired, man. Just got hired.
No, he should stay in jail and pay the $500, okay? Because he makes the court go through the system in which we tried to give him an opportunity, he doesn't. But what I'm gonna do for you, okay, Mr. Jemison, I am gonna give you a $500 personal bond. But I will warn you, sir, okay, you need to come to court. You need to go to court in front of Judge Garrett, take care of your matter. Otherwise, if you don't show up, sir, next time, it's not gonna be that, hey, I got homeless, I just got a job, okay? You're probably gonna have next time a monetary bond, but I'm giving you one last chance. Do you understand that?
Yes.
Okay, and that means that you can't come in by Zoom. You have to come in by person to Judge Garrett. Okay. That concludes your arraignment. What's your court date, sir?
February 25th,
That is correct. In front of who?
Judge Garrett.
That's right. Go to court, handle your matter, sir.
Thank you.
You can step aside. What's your name, sir?
Jesus Rosales.
Sir Rosales, this is Magistrate Chartea, sir. You're here on a criminal matter. Case number is 000-5839-403. You are defendant 3 in this case. You have a defense counsel. Go ahead, Counsel Reagan.
With Reagan, we have Mr. Gonzalez, waive the reading, stand mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are February 25th, 2025. It's a probable cause conference followed by preliminary examination, March 4th, 2025. Both matters are in front of Judge Taylor. Mr. Rosales, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Ma'am.
Okay. Counsel Douglas, this is from 2000, 25 years ago.
Yes, Your Honor. Your Honor, Mr. Rosales, the people wouldn't object to a 100,000 personal bond. If he turned himself in, I wouldn't ask for a tether. If he did not turn himself in, I would ask for a tether. Your Honor, there was 2 co-defendants on this case. One of them, the case was dismissed at exam. For the other one, he was convicted on 2 counts and sentenced to prison. He's actually currently still in prison because he picked up another armed robbery case while on parole. It's not clear what will happen with Mr. Rosales' case. This is, like, as you pointed out, from 25 years ago, but these are very serious allegations. Perhaps this ends if he shows up at the next court date, but we're not sure how he came to be in custody today, and so we do think that is relevant to the decision. But I'm not objecting to the 100,000 personal. Depending on how he came to be into custody, I would ask for a tether.
Hey, DDC,
Yes, ma'am.
can you tell us how did Mr. Rosales come in to custody at DDC?
He was arrested on a warrant of arrest.
From this
Warrant of
case.
arrest.
From this case. I got pulled over in Farmington Hills, ma'am.
Thank you. Okay. Counsel Reagan, go ahead.
So, Judge, this case is in 2000. Like Ms. Douglas said, one of the co-defendants was dismissed. My client served 8 years in prison. He did a clean slate program, tried to get this matter, didn't know that this matter even existed at the time. When he found out about it in prison, he tried to get it cleared up, tried to get the warrant arraigned when he was there. So I'm just asking for the personal bond. He now knows he's here. He works. So I'm asking the court, he lives in the city, in this Metro Detroit area. I'm asking the court to consider personal bond for him, Judge. I don't think a tether is necessary in this particular case.
Does he live in Michigan?
He does, Judge. He lives in the Metro Detroit area. Has 4 children.
My
Counsel
daughter's,
Douglas response? Sir,
I would
please don't
just-
say anything.
Okay, if I'm understanding properly, I think Mr. Reagan is saying that Mr. Rosales was in prison for a time in between when this was charged and now. If that was the case, then I wouldn't ask for a tether because he should have been arraigned on it. But I'm not sure if I'm understanding Mr. Reagan properly.
Yep, that's right. He was in prison when this, he was in prison after this case. He did a lot of prison time. And then he was trying to do right to get it cleared up while he was in prison during that particular time.
Okay. With that being said, Mr. Rosales, bond is gonna be $100,000 personal bond. Understand, no firearms of any kind. Go to court, handle your matter. You understand
thank
that?
you.
Okay, you step aside, sir.
Now,
Judge, quick, does he have any court dates?
Yes, I gave the court dates.
What were the court dates?
February 25th and March 4th. Both matters are in front of, hold on, what are they? Judge who? Judge Taylor.
Thank you, Judge.
Thank you. Gentleman in orange, what's your name, sir?
Deshaun Ross.
Is it Deshaun? Oh, hold on. Here you go. Mr. Ross, I'm Magistrate Child Faster. You're here on a criminal matter. Case number is 25055899101. You have an attorney. Go ahead, counsel. Ms. Lisa, give me another one. Here. Wrong name. Counsel Reagan, you wait for my reading, stand mute. We just lost Mr. Reagan. Counsel Reagan,
Yes, Your Honor.
we got Mr. Ross. Do you wait for my reading, stand mute?
To Your Honor.
Okay, has he been advised of his constitutional rights?
Yes, Your Honor, I'm sorry.
That's all right, I'm gonna enter plea of not guilty. Mr. Ross, you have court dates, February 24th, 2025. It is a probable cause conference, followed by preliminary examination, March 3rd, let me repeat that. March 3rd, 2025. The examination is at 1:45 PM, and I believe the probable cause is at 8:30. Both matters are in front of Judge Shakay. Mr. Ross, while this case is pending, you're not to possess any firearms or any other dangerous weapons, and you're not to have contact with any witnesses of this case. Understand that, Mr. Ross?
No witness, yes, and you said not guilty. What
Yeah,
did you say?
your attorney entered a plea of not guilty for you, sir.
Okay.
Okay, DDC,
Yes, ma'am.
you have the court dates.
I do, the 24th and the 3rd.